My name is Festus Ogo. So, as we all know, the matter was slated for ruling today in respect of the application for binding over that was filed by Excellence Link Company. And on our part, we responded to the suit, we filed our counter affidavit, and we did our written address. We equally adopted the written address, and the matter was slated today for ruling on the case. But when the erudite magistrate, in a very detailed analytical ruling, was considering the matter, the magistrate held the view that because there are irreconcilable conflicts in our different affidavits, that it will be proper, it will be necessary, in the interest of justice, for us to call our witnesses, for our witnesses to enter the witness box, so that she can observe their demeanor and know exactly the truth of the matter. We quite agree with her. We agree with the learned magistrate that the position of the law, as upheld by the Supreme Court in plethora of cases, is that when you come to court with an affidavit to say someone has done this thing, and the other party comes to court to say I have not done this thing, and we are not able to reconcile the two, we don't know which is true and we don't know which is false, even though ours is true, then the proper thing to do is to convert the originating summons to a writ, so that we can call witnesses. We enter witness where they begin to ask them questions, so that we can get to the root of the matter. But on our part, we feel very fulfilled, because from inception we have made it very clear that this matter, because of the hostile nature of this matter, it cannot be settled on the face of affidavit evidence. We've said it from the one that this matter cannot be settled by affidavit evidence. That for this matter to be proved, because they are dealing with criminal allegations, they cannot be settled by mere affidavit evidence. The Supreme Court has said it. Even in this case of Mashima and Lawan, the Supreme Court said no. When there are issues of crime, you cannot go ahead to now begin to use affidavit evidence to settle it. It cannot be settled by it. So we are on our part comforted that by the time they bring their witnesses and we bring our witnesses, we confront their witnesses doing cross-examination with facts, then the truth of the matter will be brought or will be demonstrated to the court, and we are confident that justice will be done in this matter. So what the summary, in short, is that the trial judge, the trial magistrate, was unable to reach a conclusion because the affidavit that we filed are conflicting. We said this, we are saying that. They are not bringing any proof to support it. So the magistrate was unable to reach a conclusion. So to reach a just conclusion, the magistrate has ordered that everyone should go and file their pleadings so that we can bring everybody to that witness box. So they will bring their witnesses. We will ask their witness some questions so that the court will see whether they are a witness of truth or not. We will also bring our people. We will ask them questions. They said they have destroyed properties. They said they have done this. They said they have done that. No, they will ask them questions too to know the truth of the matter. By the time we are done with that, the learned trial judge or the learned trial magistrate will now be able to come to a just, upright, and clear conclusion in the determination of the matter. Thank you. You see, this issue is not about this man, or about Galadima, or about Afajamu, or about Engineer Fallowe. No. This is a struggle against oppression, systemic oppression. This is a struggle against injustice. This is a struggle against extortion, not just of the rich, but of the poor masses of our people. So we like I will always say, that the struggle continues. We have always been law abiding. We will continue to be law abiding. We will never breach any public peace. There is a matter already at the High Court to show how peaceful we are. There is a matter as we speak at the High Court coming up on the 29th of October 2023, where we are challenging whether they have the jurisdictional power to do unilaterally, that means on their own, increase the rate, the tariff by 200%, despite the excruciating hardship in the country. Is it humane? Is it even logical? So we are already in court, at the High Court, for the court to determine whether they have the power to increase the rent. When you beat a child, why do you expect the child not to cry? They are bringing us to court to challenge why we are complaining when we increase rent by 200%. This court cannot be an instrument of oppression. It cannot be an instrument of intimidation. Then let them take us to any court. Will be there to defend our people. I want us to be calm. I want us to remain law abiding. I want us to remain resolute in pursuit of this thing. We are not doing it just for ourselves. Some of us we are able to afford. How much is it? We are able to afford it. But because of the poor, because of the injustice, because of the unfair nature of the increase in the tariff, we are saying enough is enough.